Let's talk about legal costs in this video. The general position is that the dogs in the street know that legal costs can be very high, can be very prohibitive, and most people, most rational people, will try and stay out of the courts if they can help it, because they know that there's always a risk when it comes to costs. In other words, the general rule is, and that's what I want to discuss in this video, the general rule is that costs follow the event. That basically means that the winner takes all. In other words, if you win your case, you are, in the normal course of events, entitled for the other party, the losing party, to pay you your costs, to discharge your costs. And that's as it should be. So costs following the event is the usual rule in legal proceedings, and that is pursuant to legal principles that have always been established down through the years, and also now pursuant to the Legal Services Regulation Act 2015. So it's actually on the statute books in Ireland. Section 169 subsection 1 of the Legal Services Regulation Act 2015 provides costs to follow event. And it sets out there the situation that the general principle is that a party who is entirely successful in civil proceedings is entitled to an award of costs against a party who is not successful in those proceedings, unless the court orders otherwise, having regard to the particular nature and circumstances of the case and the conduct of the proceedings by the parties, including conduct before and during the proceedings, etc. In other words, from A to G, there is a number of things that the court can look at in setting aside the general normal rule that costs follow the event. And if one party, for example, exaggerated his or her claim, or if the manner in which the parties conducted all or any part of their cases was such, or if the conduct before and during the proceedings was such that the court might see a way, in the interests of justice and so on, might see the way to exercise their discretion and to make departure from the normal rule that costs follow the event. But that is the default position. That is the default position pursuant to the statute that's on the statute books in Ireland and pursuant to well-established legal principles down through the years. There was a recent case there in February 2021 decision, only last month, in the High Court involving a lady, Stephanie Maloney. She was the plaintiff, and she was suing Cashel Taverns Limited that was in voluntary liquidation, so that wasn't going to be of any benefit in terms of a cost order. And the second defendant, though, was Liberty Insurance, DAC. Now, the substantive case between the parties was decided in December 2020, and in that case, the Liberty Insurance, DAC, the insurance company, successfully defended the case, and the plaintiff, Miss Maloney, was unsuccessful. And in that situation then, the normal position would be that costs followed the event. Miss Maloney must pay the costs for the insurance company. But in this, that was a December 2020 decision. In February 2021 then, this decision deals with the question of costs, and she applied to the court for her costs, or at least not to have costs awarded against her. She applied to the court for the court to exercise its discretion and to set aside the normal rule that costs follow the event. And she made her application based on a number of things. For example, she argued that the conduct of the plaintiff should be given due recognition by the court in not making any order as to costs against the plaintiff. The parties had agreed admitting many documents to the case without the need for formal proof. So she was arguing that her conduct in that regard should have been given recognition. The court held, however, that the agreement as to the documents benefit both parties because it saved costs for both parties in terms of admitting documents formally to evidence and so on. So the court held that that agreement, it would be a manifest injustice if the second named defendant, that's the insurance company, was deprived of costs as a result of this pre-trial agreement between the parties. She also contended that the proceedings dealt with a novel and substantive point of law, and that she had confined her case to a single substantive issue, thereby saving time and costs. The court didn't agree with her. The court held that this was not enough. The court did not agree that there was any novelty to the issue, the substantive issue, and she didn't win on that head either. The plaintiff also argued that the judgment would be of particular value to the insurance company. The High Court again did not agree, because it held that the decision that it made was based on the particular circumstances of the case that was put before the court. The plaintiff also sought to rely on a Calder Bank type letter sent by the insurance company's legal representative, which offered that the insurance company would bear its own costs if the case was withdrawn by 2 p.m. on the same day. Just to be clear here, the insurance company offered to bear its own costs if the plaintiff withdrew her case on the day that the letter was sent. She felt that she didn't have sufficient time to consider the offer and so on, and therefore she didn't withdraw it. But the court said she couldn't get any benefit, or couldn't have the thing set aside now, the normal rule set aside now. She had decided to bring her case. She had chose not to withdraw it. That was her decision, and she must live with it. The High Court basically held then that there was not a sufficient reason to depart from the general rule that costs follow the event, and awarded the costs in favour of the insurance company. The defendant, that's the insurance company, had been entirely successful in defending the case and having regard to all matters set out in Section 169, subsection 1 of the Legal Services Regulation Act 2015, by which, to make the decision, the court held there was no reason to depart from the usual rule, including legislative provisions and legal principles. It will be interesting to see if the Court of Appeal decision by Gemma O'Doherty and John Waters, for example, I'm not sure what the position there is in relation to costs. I think the court allowed the parties to bring an application in relation to costs within 2 weeks or something of the decision. I'm not sure whether that happened or not, but you would imagine that Waters and O'Doherty had costs awarded against them in the High Court judicial review application. Then you would imagine they'd probably have it awarded against them in the Court of Appeal as well, if you were to take the general legal principle that costs follow the event, and if you were to accept, and you obviously have to do if you're a Democrat, Section 169, subsection 1 of the Legal Services Regulation Act 2015, which sets out quite clearly and quite expressly that costs follow the event. In other words, the winner takes all and the loser pays the costs for the winning side. Hope you find this video useful. If you do, I would appreciate if you gave it the thumbs up down below, and you may be interested in subscribing to my YouTube channel, on which I publish videos every week about Irish law, property, business, books, general commentary and so on. Thanks for watching.